Every day in the USA, people find themselves in court.
Okay, let's go to number 4, 252-0006508. And I have Reed Kaplan, represented by Craig McCreary. And then we have Juanita Barrett, Richard Barrett, Ryan Barrett, represented by Mr. Kiernan. All right, let me just get into that file, folks. Give me just a minute. Okay, so I did see the order shortening time and an order for show cause. Mr. Kiernan, I guess I'll let you go first. It sounds like you're probably asking for some additional time, so I'll decide that issue first.
Yeah, I would ask you to set to the civil docket on Wednesday. I was not aware of this till 11 o'clock yesterday, and they had full knowledge of any incidents that occurred on the 15th for over a week. So I believe in good faith. I should have at least a little bit of time to prepare. I'd also like to know that at this point, there's not a police report in the record, Your Honor. So at this point, any sort of statements which say that a police or an arrest occurred are completely hearsay. We don't, what we have, at least in the facts, are that there was an arrest that took place off the premises that did not involve any of the tenants that are involved in this, not on the property. And we don't even know what they are arrested for. My clients have said that they think that it was an outstanding warrant, so it really had nothing to do with drugs. So I'd ask that we just set this over to the next available docket to try and get a little bit more information, Your Honor. I think a police report is really crucial here because right now all the evidence we have is extremely hearsay. Especially having to do with whether there was any drugs involved or anything like that. And I don't think waiting for a police report when we have, such an extreme case here is that unreasonable. So I just asked for a short set over to the civil docket so we can get more information, including a police report. So quite frankly, we can prove whatever happened even happened. Because at this point, all we have is that something occurred off the premises, not involving my clients. And we don't even really know what was at issue here, Your Honor. We have a whole bunch of declarations from people that have already been adverse to my clients throughout this entire process. So I believe that those, should not be taken at face value. Again, I'm just asking. I feel like if we had a police report here, I'd be arguing very differently. But we simply don't have the evidence that we need, Your Honor.
Mr. McCreary, I guess first your position on setting this to Wednesday.
I would object to that, Your Honor. This, as evictions go, this one has just kept mounting and mounting, and my client is not accused of any bad faith. In fact, when we look back to the original filings, I believe he had in his declaration all the efforts he made to help these folks when they decided that they wanted to move. He's fixed their car. He's helped them out on multiple levels. And all he's gotten is a big bill for the struggle that they create. So to put this over, I certainly object to that. And the fact that eyewitnesses observed an arrest is not hearsay. They have the capacity to testify to what they observed, and it's not an out-of-court statement being offered for the truth of the matter. So the person who was arrested is somebody who is known to stay with or live within the defendant's unit. And I wasn't there. I didn't see that drugs were seized. But whatever the case, the folks who saw the arrest observed that it was related to drugs by whatever measure. Drugs are not the only issue here. Standing out in the middle of the street or out on the front porch, flipping the bird to neighbors, and I know the court doesn't want to hear a verbal repeat of what you read in the declarations. And to say that the people who signed these declarations are against the defendants, well, I think just about anybody placed in proximity, in near proximity to the defendants, would find themselves against them based on the conduct that's showing up. And to suggest this is somehow a neighborhood conspiracy to just take a swipe at the Barretts it's not believable. It just isn't believable. These folks in this neighborhood, we're not just talking about the deaf woman next door who can't sleep because of the noise, or the gentleman who has an amputated leg who can't get his caregiver to come in and help him because they're afraid of the Barretts. We're talking about people across the street, down the street. The Barretts have a pretty wide swath of activity, and we entered into a stipulation, and the stipulation said we can get to court on short time if the Barretts are doing the things that they're not supposed to. Well, we're here on short time. It's not easy to coordinate what a neighborhood is saying about things, especially when I have trials going on and so forth. But in the end, we have an original action based on a 3-day notice to quit for waste, nuisance, and illegality. And the things that happened in that instance were bad enough that, gosh, we better enter into a stipulation. And if there's any more foul play, the stipulation is triggered and there should be an order for a writ of restitution. This neighborhood needs relief from these folks, and waiting additional time is not the answer. It's a little bit of a powder keg over there. And we already have Mr. Clegg, who has a restraining order against Mr. Barrett, and Mr. Barrett walks out in the hallway after the hearing when the order is granted and verbally assaults Mr. Clegg. These folks don't recognize boundaries, Your Honor, and I don't know. I don't want to be overbearing in my argument, but this is a situation that deserves an order for a writ and get these people moved out of this neighborhood.
And Your Honor, I would just, or
Go ahead.
may I? Okay.
Yep.
I'd just like to note there's mutual protection orders both ways on this case. There's very much material show of fact as to what's happening. There's an agreed order that my clients are going to be vacating in a few weeks or at the end of next week, or on the 1st. Again, defendants knew that they were going to be filing these documents probably at the beginning of the week. They did not give me notice till 11 o'clock yesterday. There is no police report in there which substantiates these documents, which would provide you evidence for a show cause hearing. I'm just asking for a short continuance to get time so we can get evidence so we can verify what happened, Your Honor.
So, Mr. Clegg, no. Mr. McCreary and Mr. Kiernan, my question, I guess, for you, help me understand a little bit more about the underlying, I don't know if it was a CR2A that you all had agreed to, kind of what were and then I know there were subsequent, motion to vacate and stay writ and all those sorts of things, but what's kind of between the parties, the underlying agreement with regard to tenancy? Because the most recent agreed order I see was that on page 2, lines 20 to 21, the parties desire to settle this and return possession of the subject premises to plaintiff without further expense, inconvenience, uncertainty of trial.
Right. So I think Your Honor last week mentioned that you were interested in the case that involved compromises that waive rights to the Landlord-Tenant Act. And what happened is the Barretts promised to pay rent and they failed to do so. And so we brought it on so that there would be an order for a writ. Counsel raised the case that said, hey, we couldn't agree to that basically because it was a waiver of the right to I think you could reduce it to, we would have to give a 14-day notice if rent is going to be the basis for any type of settlement agreement. And so now we've got to readjust how we approach those and give more lead time and so forth. But that agreement was just saying that issue, no need to argue it. That's out of the picture, but we still are in a position where our stipulation is in place. And the failing of saying, gosh, well, they're supposed to be out by the end of the month is we can't trust anything that they say they will do in the first place. But beyond that, then we have to go and get the order for the writ at that point and set the sheriff, which is now apparently getting to about 2 weeks out. So now we're mid-April, and this, I mean, I'm sorry, but what comes to mind is, geez, what do we do if the temperature outdoors starts to rise? This is going to become crazy. And I know that's a little tongue in cheek, but this situation in bad weather is unmanageable. What happens when people start feeling comfortable being outside? Anyway, the agreement has in it provisions that I provided with the motion for today's hearing at paragraph 3 of the declaration of Reed Kaplan. It refers to paragraph 3A of the stipulation that no drug activity basically on or around the subject premises.
Okay. That's kind of what I was trying to get at, is whether this was part of the agreement.
Right.
So
And then 3D says defendants shall not speak to, gesture to, communicate, or otherwise make threats of violence or property damage, including malicious intentional threats towards any person residing on Delaware Street. So we reached an agreement that tries to manage how these folks project their aggression into the neighborhood, and they've clearly violated that. The declarations are disgusting. And then paragraph 3E says defendants Juanita Michelle Barrett and Richard J. Barrett and Ryan Barrett, and I know that counsel didn't agree regarding Ryan because he wasn't a party to it, but shall not cause or allow to be caused any excessive noise or other disturbance around the subject premises during the time the defendants are in possession. And I mean, we have all three of those provisions violated in spades with these declarations, and we have the history that got us here in the first place. And so what is the point of having a stipulation like this that has triggers for the eviction of people if delay is the answer, if trial is the answer, when the evidence is overwhelming? It's just overwhelming. So we're asking that the court sign the order for the writ of restitution so we can keep this neighborhood safe.
Mr. Kiernan.
Yeah, and I would just like to say it again, there's mutual protection orders both sides. So there's been protection orders granted. So that means there's a clear, at least material issue of fact as to that the harassment is going both ways, Your Honor. There's disputes. My clients dispute that, any of these kind of verbal harassment cards happened. As noted in the declaration, the police have not came out. They did not feel like there was enough evidence for them to come out for any of these. So there's really no physical evidence. And I do agree that the drug issue could be potentially a huge issue for the eviction. But again, at this point, we don't have any evidence. What we have in the record is that something happened off the premises, not involving my clients. And we don't even know that it was a drug arrest, quite frankly, Your Honor. They are saying that it was, but there's nothing in the evidence that states that. If we had a police report, I'd be, I would have evidence which states that this happens. As part of the stipulation, we agreed to a show cause hearing, Your Honor. That means that we are going to be able to present evidence and have an actual hearing where we're going to be able to discuss issues. I believe that when I have, less than 24 hours to prepare for it and no police report with no evidence, that's simply not enough to protect my client's interest. For a show cause hearing. Again, they had full knowledge of all these things at the beginning of the week. They could have given me more time to do that. They could have provided a police report to do this that would have had evidence that showed that this happened. I just want a short set over to see if we can get evidence to show, because I would concede that if there was drug activity on the premises, that could be a violation of the agreement. But right now, we just don't have any evidence that occurs.
Quick question, I guess. Were you able to notify your client of the hearing today?
I was.
Okay. And are they, I'm trying to figure out if they were aware of today's hearing.
They were, and I did speak with them extensively yesterday. Okay. So I'm a little bit confused as to why they might not be here, but because
Okay.
And my client sent me a chat that said the Barretts do not have a restraining order against the neighbors. I don't know that counsel's statement that that restraining order is mutual. I didn't understand that to be the case when it was entered. And just one other issue. I was in trial on Monday. A variety of allegations came in over the course of this week. The ability to get a motion out the door after having an opportunity to review all of the statements and so forth. I did not intentionally sandbag counsel on this, and I know we have a good working relationship. I'm sorry that it was as late as it was, but there was no holding on to it. It was making decisions on whether or not this was. I could read the stuff and then make a decision whether I'm going to bother Your Honor to hear it. And after I had a chance to read it, it certainly warranted it.
Yeah, I understand that. I mean, the allegations of the conduct are Friday and Saturday. You know, that motion was filed Thursday. I mean, there's no real delay in there. I guess, I don't know if anyone's happy with this, but I am going to, if the parties are available, set this for a decision to March 26th so that the tenants have the ability to provide a declaration or testimony to their lawyer in response. Obviously, I'm not faulting anyone for, they got an order to shorten time yesterday. I understand that. I just think the legislation's really clear that, you know, we want to give tenants an opportunity to stay in their homes. And I think a short set over, just, you know, 3 court days is appropriate. Are the parties available Wednesday for our 2 o'clock civil docket? It looks like we have a lot, but a lot of those are shorter matters, so we would have time to hear this.
I will make myself available.
I'm certainly available. And I would say if any additional actions happen over the week, I'm okay with including them in the show cause hearing, just in case the situation does escalate, which I don't believe it will.
And, you know, one of my reasons for, I think if the affidavits were documenting that on I think it was the 14th, the specific drug use was the Barretts, it's a little bit different than what I'm reading, that it was a friend of theirs. I do understand that the agreement is they're not to allow it. You know, I just can't say without further input from both parties whether, you know, they were knowledgeable of this and allowed it. And so I would like them the ability to respond to that.
I would just say that the drug issue is if half, maybe not even that much of the issue. We've got aggressive behavior
A
and
disruption outside directly by Mr. Barrett. Yeah.
and horrific comments. I mean,
yeah, no, believe me, I mean, it's one of the reasons I'm not setting this out further. I do think that the landlords are entitled to resolution. I'm trying to balance that with an opportunity to be heard by the tenants. And so I think this brief, not even full 3-day court day set over, really 2 3/4 court day set over makes the most sense to balance everyone's rights in this case. So if the parties are agreeable, well, not agreeable to that, if the parties are available March 26th at 2 o'clock, we'll go ahead and make a decision at that time.
That works. Yeah, I feel like both of us are a little bit not happy, so maybe that's not a bad decision.
I'm madder than counsel, for the record.
Deal.
I think that's probably fair to assume. Thank you, Your Honor.
Okay. All right. We'll reconvene March 26th at 2 o'clock. Thank you all.
All right.
Thank you.
Okay. Anything else on this docket?